case is.
I mean, I wrote several op-eds with several variations of the outcome of the case, and you know, I gotta be prepared.
So did you have an op-ed for this outcome, for the outcome that happened?
I had an op-ed for the Supreme Court upholding the law, but not this variation. I'd written like 3 different various outcomes. I could pluck. I had nothing for this. Nothing. This was unprecedented.
I think it's defensible. I'm actually trying to defend it a little bit. So.
Oh, I didn't say it was indefensible. It was large and unpredictable.
Yeah. If only because, you know, Roberts rather than Kennedy.
Where's everybody from?
From Canada.
Oh, we're in Canada.
St. Catharines, Ontario. I'm from Ottawa originally, but grew up in the Niagara region.
Cool. And you're from Notre Dame?
Yeah, I'm from Notre Dame. My name is John Robinson.
Robertson? Where are you from?
I'm from here, School of Communication.
Oh, welcome. I know you. Where are you from?
Central Michigan University.
Central, Chippewas, no, right?
That's right.
How did you? You're from?
I'm from Good Afternoon.
That's right, from Drew, right? That's right. And you're from. Okay, well, my efforts to stall time. My name is Josh Blackman. I'm a law professor at South Texas Law School. Hello. Hi. I guess we'll get started in a minute.
John, you specialize in health law?
Josh, no, I don't, and it's only by fluke coincidence that health law intersects with constitutional law this year. Might never happen again. So this is for my one-time invitation to this conference.
Be more assistant suicide case.
They're still in session down there, so get a couple more minutes.
All right, I can solve. I can kill time.
I think actually, health law intersects with constitutional law all the time.
It does. I was being somewhat facetious, but not this clearly. But no, I don't really have any strong background in health law. And I think actually one interesting element to this is a lot of professors of health law who really did nothing in constitutional law forced to come to speed very quickly on this. There was one guy who's at Wake Forest, does health law. What's his name? It'll kill me because he's a good friend. He was actually one of the preeminent health law experts, and he was involved in the draft of this law from the beginning. A lot of people were actually asking him, so is this constitutional? He's like, I haven't taken common law since law school. I didn't know anything about this. And then I was doing an interview with him. He was like, yeah, I had to go back and read all this common law stuff, which none of it I'd remember. So you had this interesting dichotomy of this case where common law guys had to become experts in health law really quick, and health law experts had to become experts in common law really quick. Neither of them probably knew what they were talking about in the other field subject. So I'm going to stick to the common law stuff.
Josh is like getting anxious. He's all like,
no, I'm just doing stand up.
No, I was just trying to. So just ended?
Yeah, you and me both. I mean, I don't even quite know what
How many people are down there?
And I think one of the failings of Healthcare Channel was that
How was she?
common law people weren't quite attuned to a lot of the policy implications
No, that one
of the
was
Affordable Care Act.
before.
And I think that's one of the largest failings of
Yesterday.
this challenge. The challenge is so far
They're
divorced
both
from
actually from University of Michigan.
reality in some respects. And I think,
Well, Randy Barnett was so far.
well, Randy's actually writing the foreword to my book, but Randy's a good friend. But I'm actually writing a chapter in the book about how.
Yeah, cool.
I
So
think the argument that
we agreed
Commons
we were
Clause
just.
argument that he came out with the cause.
We're gonna make up the time during lunch. So,
But, yeah.
like we're not
Well,
shortening
it almost
anyone's
worked.
time. We're just.
It actually kind of did
We'll figure
work.
out
Yeah, I mean, it did work, really.
Yeah.
Do you want me to?
The government never really had a good answer to it either, so it wasn't that bad of an argument.
Well, anyway, we can talk about that
Yeah.
later. I mean,
Yep.
I honestly don't think that there was anything to it in the first place.
Yeah.
Did he tell you to wait, or are you starting? So I was going to get a cup of coffee.
Go, please, go get coffee. They're running late downstairs, so I think I'm just up here doing stand-up and killing time. So, let's see. And you're at the law school?
Yeah,
And do you specialize in health law or constitutional law or?
specialize is too good a word. So, I do a whole bunch of things, and one of them is the interface between common law and health law. So, but still, I was taken by surprise, as everybody else was by this decision.
What was your, if I can ask, but not to put you on the spot, but what was your initial reaction to this case when the law was first enacted? What do you think of the challenge when, you know, this challenge first came down the pike?
So I thought that on the basis of Filburn and Drake, that this would succeed in the face of a Commerce Clause challenge. I thought that joker in Massachusetts was actually a brilliant guy who said that Congress can require you to buy broccoli but not eat it. Really brilliant fellow. That sort of caught it right. As you know, it's the only oral argument in history where broccoli came up and seemed to be a metaphor for how far can Congress go. So I didn't see the Commerce Clause challenge as should have succeeding. If you'd asked the other question, were there votes on the court for the Commerce Clause challenge? It all went down to Kennedy, and as you know, with Kennedy, it's whatever he gives you that day.
It's funny, actually, the cover of my book is actually, I'm thinking of just having a piece of broccoli, and that's it. It'd just be a white background with broccoli.
I think if you want the book to sell, you might want to use something else.
I'm sure the Supreme Court, but I made a mock-up of cover just like broccoli and the Supreme Court.
There you go. I'm sure you spelled broccoli right. It's always a challenge.
But I can't spell potato right.
But we're from Indiana, and we don't like Dan Quayle jokes, so just be very careful. Yeah. He's our most celebrated citizen.
Oh, really?
We've got Derek Jeter here in Kalamazoo. We've got,
That's right, Derek Jeter's from Kalamazoo.
Dan Quayle.
I forgot that. I'm a Yankees fan.
Yeah.
I was wondering why I saw a picture of Derek Jeter in a hotel. I was trying to figure that out.
Where'd you go to law school?
I went to George Mason Law School in Arlington, Virginia.
And where is South Texas Law School?
Houston.
Oh, that's kind of south.
Not really. It's kind of central. I mean, it's not like South Central. That's a totally different deal.
Yeah.
What do you think of Houston? I've only ever been there once.
I love it.
Feel of it. Yeah.
I like it. I've been there now 2 months. It's a lot of fun. It's a cool city. They gave me a job, so I've been thinking.
Yeah.
That's nothing to complain about.
It's close to New Orleans too, which is
Maybe 4 hours from New Orleans, I think. And I've never made the drive to New Orleans. We'll eventually though.
oh, it's worth it. Let me email me when you do. I'll tell you all the good places.
When you go to Waco, there's a great Dr. Pepper museum.
Really?
Yeah, it's the only Dr. Pepper museum. And a great...
No, I lived there for a while ago.
Oh, check it out.
oh yeah, it's really worth the drive.
Hey, come on, we didn't start yet.
Galveston is not, it's not as exciting as New Orleans, but Galveston's a lot closer.
I will check out Galveston sometime soon.
That's nice a lot.
I have a couple of times, yeah. I live on the opposite side of town, so it's kind of nice.
Maybe Tuesday night, one of these days, we go upstairs.
Yeah, that's the.
Hey, I think we're good. People just, good. Yeah, people just all come up the stairs, so. Okay, let's do it.
Well, welcome everybody. This is the mini symposium on the ACA decision. My name is Nate Stout. I'm a PhD student in the philosophy department at Tulane University. For those of you who don't know, I think we're still missing a few of our panel members. This panel actually started because Fritz and I are editors. He's the editor-in-chief. I'm the managing editor at Public Affairs Quarterly. And we recently accepted papers for a special issue to be published on the decision. And we got such a strong response for it that Fritz and I are in the middle of a book proposal to sort of bring all of these papers into an edited volume. So this panel sort of arose out of the really strong response that we had for that. So we're excited to have some of the papers presented here and get some feedback on them before we publish them. So with that, I'll introduce you all to Josh Blackman.
Hi, everybody. One more thing. Do you want to just remind about the format because it changed a little bit?
Oh, yeah, we did have a little bit of a schedule change. One of our presenters in the 12:45 session was unable to make it. So we're going to bump everything up a half an hour, and at the end of the mini symposium, we're going to have a half-hour open discussion roundtable kind of thing. So we can talk about all the papers then, or we can, if y'all have other issues you'd like to bring up, we can talk about those as well. So, okay, all right, thanks.
Good morning, everyone. My name is Josh Blackman. I'm a law professor at the South Texas College of Law. Thank you very much to Drew, and Nate, and Fitz, and everybody else for bringing me out here. This has been a very interesting conference because it brings together people of very diverse interests. People with medical background, with humanities background, and for some reason a lawyer. Now, why is a lawyer? Oh, there's another lawyer in the house. Why would you invite a lawyer to a conference of medical humanities? One very important reason, the Supreme Court very recently had a case involving things that are very near and dear to your heart. Healthcare. Just this past June, the Supreme Court decided NFIB v. Sebelius. This was the healthcare case, or as you might know it, Obamacare. This case considered whether Congress, in its efforts to pass comprehensive healthcare reform, could mandate that individuals purchase health insurance. If individuals fail to buy this health insurance, just ignore that. So in their efforts to make sure that everyone would have health care, they mandated people would have to buy it with certain exceptions. Now this was a law that affected a vast section of the economy. And when it was originally enacted, there was very, very few doubts about whether this law was constitutional. If I were to go back to a constitutional law class in law school at some point in, say, 2009, and for my final exam question I said, could Congress pass a law imposing a tax on people who choose not to purchase health care? The answer would have been yes. If a student would have said no, he probably would have failed the exam. Fast forward to the year 2012, where the Supreme Court, on a very narrow basis, almost struck down this law as violating the Constitution. In fact, 5 justices said that Congress did not have the power to enact this law, but only by a very curious to saving construction by the Chief Justice with their 5 votes to save the law. So what happened between 2009 and 2012? The Constitution certainly didn't change. There's been no amendments. There's been no changes to our fundamental laws. This wasn't a challenge based on, for example, originalism, or what did the founders think about commerce, and what did the founders of the Constitution think about our nation. But rather what changed is how people viewed the Constitution, how the people were able to affect how courts understand constitutional law. This is something we call popular constitutionalism, the notion that the people can actually impact and affect the way courts construe the law. There's this notion that when you make an argument about the law, it might be kind of crazy. To quote Jack Balkin, it's kind of off the wall. But if enough people get behind an idea and accept it and kind of internalize it, it becomes on the wall, something which can be understood and realized by people. And this is in many respects what happened with the healthcare case. You had an argument that at the outset very few people took seriously, but due to the efforts of a number of leading academics and scholars, not to mention leading Republicans in the government, Tea Party people, who kind of rallied around a constitutional idea that the government cannot force you to buy health insurance. The government cannot force you to buy broccoli. Broccoli, the enduring image of this entire challenge. Who here actually likes broccoli? Does anyone actually like broccoli? A bunch of doctors, okay, everyone raises their hand. I don't like it. But for whatever reason, this became the enduring image of the challenge. Can Congress force you to buy broccoli? So this talk will focus on how this challenge went from really something small to something that almost went to the Supreme Court and invalidated a signature piece of legislation of the President of the United States and could have almost drastically changed the way we look at constitutional law. This is a story of what went on both inside the court and outside the court. Some of our other speakers will focus a lot on the justices and what do they do and how do they reason. My focus is more precise. I'm looking at the people outside the court and how they affected the way the judges inside the court look at the Constitution. And this is really the process of popular constitutionalism. Let's start with a little bit of background on the individual mandate. The mandate was not invented in 2009. In fact, it has a longer history. It dates back to the early 1990s. You might remember something called Hillary Care, which was President Clinton's attempt to make some sort of universal coverage. As an alternative to universal coverage, like a single-payer system like they have in Canada, a number of conservatives advanced something called a mandate. It was a free market alternative. It said, if you don't want to buy health insurance, pay a tax. So rather than forcing people into a, sometimes a single-payer system, they gave people the choice. This was a conservative free market idea. Fast forward to the late 90s and early 2000s. governor of Massachusetts, Mitt Romney, he's currently running for president. He imposed an individual mandate in his state. He required that all citizens of Massachusetts purchase health insurance. In fairness to the governor, there's a difference between the states and the feds doing this, but we'll put that aside for now. Fast forward to the 2008 election. You had candidate Clinton versus candidate Obama. One of them wanted an individual mandate, one of them didn't. Hillary Clinton wanted it, Obama opposed the mandate. It's actually fascinating to go back and watch the debates from 2008 where Barack Obama said, I will not have an individual mandate. That's not the way to do it. I guess it didn't really matter because on election night everything changed. After the election, Obama said, now we're going to have a mandate. That was his new plan. This law was in debating for almost an entire year before it was enacted. Although almost all the debates focused on policy issues. Should we have a government option? How do we structure healthcare markets? Do we have these things called exchanges? There are all these other ancillary issues. But one issue was really kind of pushed the bat, which is this law constitutional? Other than a few scholars and a few law professors along the way, there was not a very strong sense that this law is unconstitutional. In fact, most famously, Speaker Nancy Pelosi, when asked, is this constitutional? She said, are you serious? Are you kidding? The members of Congress didn't really consider this as a valid challenge. It wasn't until the almost eve of when this law was passed that a number of senators made a constitutional point of order saying, hey, this is unconstitutional. So what happened, and why did it happen? The Affordable Care Act was passed on December 24th, 2009. I have a little timeline here to just give you a sense of the scale. This might help you explain how things progress, how quickly they progressed. By the time the law was passed, December 24th, 2009, there have already been some murmurings among some constitutional law professors saying that this is unconstitutional. Why? It was unprecedented. Unprecedented, what does that mean? Well, in law, precedent is a term that means Congress has done something like this before, and the Supreme Court has said it's okay. So if Congress has, done something before and the Supreme Court says that's fine, they can do something like this again. The argument was there was no precedent for something like this. Never before had Congress required people to purchase something. Now, people who have chosen to purchase something could be taxed. They can be regulated. If you want to run a business, the government can put regulations on that. If you want to buy a car, the government can put regulations on that. But if you choose not to do something, if you choose not to purchase health insurance, now the government can put regulations on that. They can actually fine you or tax you. It's debatable how you actually phrase it. But they can actually make you pay money if you choose not to buy health insurance. And the argument was that this was unprecedented, that none of the Supreme Court's precedents covered this. There have been earlier cases. You had a farmer, actually Fred Filburn, he was actually in Ohio somewhere, and he had wheat. And there was a law saying that you can't grow more than a certain amount of wheat. And he says, hey, wait a minute. The only people eating this wheat are me and my family and my farm animals. I'm not selling this in any market. Congress says it doesn't matter. Even if the wheat never leaves your farm, we can tell you what to do. Another recent case involving medicinal marijuana. Angel Raish in California, she had a very advanced cancer, and the only form of relief was medicinal marijuana. She grew it on her farm, where she lives in California. She never sold it, and never left her farm. She never had any intent to sell it. Congress says it doesn't matter. You are growing marijuana, we can regulate it and say you can't have it. This, the challengers argued, was different. A choice not to buy health insurance is inactivity. This is actually Nate's paper later. Congress has never regulated inactivity. Now granted, people might ultimately need health insurance, and everyone probably will at some point, but that doesn't matter. In the present, you have made no choice to buy health insurance. And some might think this argument is, trivial, but the truth is the government never had a very good response to it. The government's response simply was healthcare is different. Everyone might need health insurance, which is a response, but it doesn't resolve the fact that Congress had never before regulated inactivity. So this is kind of the backdrop when the law was enacted in December of 2009. Between December 2009 and March 2010, there were a number of debates in the Senate to try and get this law passed. The reason why it was hard to get this law passed was Senator Ted Kennedy died. And when Ted Kennedy passed away, he was replaced by Scott Brown, a Republican. And the Democrats lost their 60th vote in the Senate. And they could no longer break a filibuster. So the bill that went to the House was not even the final intended bill. They actually had to send to the House a bill that was an earlier draft. And there were a lot of fatal defects in the draft, one of which is whether the penalty is called a tax or a fee. It was actually kind of a fatal flaw that came back to haunt them years later. But in any event, on March 22nd, 2010, with a Tea Party protest outside the Capitol, going, kill the bill was passed. The very next day, there was a signing in the White House where President Obama signed the law. This was not the end. Usually when a law is enacted, people are celebrating, they're happy, and they're ready to go, but not with lawyers. Lawyers, the buzzkills. Minutes after the ink dried on this paper, minutes, complaints were filed in federal courts across the United States. I spoke with one of the lawyers from Florida. He said he filed it 12 minutes after the president signed the paper. And they were actually in a race with Virginia, another state with this dude. Virginia had about 25 minutes. I think that's some filing problems. The reason why was because the states challenging this law knew that this was going to the Supreme Court. They wanted to be first. I'm not kidding you. So the president used about 23 pens. You can kind of see in this picture, because they give them away as like souvenirs. So you kind of draw part of his name, part of his name, part of his name. So before the ink was even dry in the 23rd pen, the lawsuits were filed. And this was something very quick. So the first one was in the Northern District of Florida. A complaint was filed with about 20 various states. And the states made a few arguments. One focused on the Medicaid expansion, which I won't talk about too much, but they said that the healthcare law places a lot of burdens on the state through Medicare, and it's unconstitutional. Okay, I'm sorry, Medicaid. The other issue was Congress can't force citizens, the citizens of Florida, for example, to purchase health insurance. Shortly thereafter, you had another complaint filed in Virginia, I think about 8 minutes later. And then after that, there were complaints filed all over the country. When these complaints were first filed, there was a small cohort of academics and lawyers who kind of thought this would be possible. But by and large, most people concede this challenge would not go too far. That really changed on October 14th, 2010, a few months later. Not to go too much into legal mumbo-jumbo, but there's something called a motion to dismiss. This is a way for a judge to toss out a case at a very early juncture if it's crap. I mean, if there's really no merit to a case, the judge will toss it out. Doesn't need to go to a jury, doesn't need to go to fact-finding, just get rid of it. A lot of people thought this should be tossed out in a motion to dismiss. This is clearly constitutional. But then you had a federal judge in Virginia in October of 2010 saying, no, this has some merit to it. About 2 months later, oops, went too far. About a few months later, you had another judge who also denied a motion to dismiss. So now you have two federal judges saying that this case has merit. And while this is going on, keep in mind what's going on in 2010. The midterm elections are coming up very soon. And if you remember the 2010 midterm elections, the Republicans swept. And they did actually very well, largely buoyed by the Tea Party. And one of the rallying cries of the Tea Party was repeal this law, repeal Obamacare, kill it. These factors are not coincidences. In order to take this challenge from off the wall to on the wall, there was a very concerted effort to appeal to the populace and say, listen, this is something that the government can't do. This is not how we view the Constitution. It was a very ingenious strategy to try to change public opinion. In another article I'm working on, I've actually tracked every opinion poll about the healthcare law from 2009 to 2012. They did them every month. And just trying to chart month by month how it fluctuated in relationship to the political events of the backdrop. It's absolutely fascinating to look at it from this kind of sociological perspective. Then, a few months later, in December of 2010, the judge in Virginia grants summary judgment. What does that mean? As a matter of law, the government loses. Doesn't even need to go to a trial. That the case is so clear that the judge can actually enter in a judgment for the challengers. At this point, the healthcare law is unconstitutional. You actually had a judge declaring that this law, which regulates a huge sector of the economy, is outside of Congress's powers to regulate commerce. When this happened, people were getting apoplectic. And note also, this is December 2010, about about a month after the midterm elections. Then the other shoe dropped in Florida. And this was the biggie. This was Judge Vinson. This was a lawsuit with 20-odd states. And the judge ruled as a matter of law, this law is unconstitutional. What made this opinion most noteworthy, though, is how the judge got there. He made a number of references and opinions to Tea Party rhetoric. He referenced, can the government make you buy broccoli? He referenced the Boston Tea Party. He referenced, colonial imagery and tyranny from the government. There were a lot of very salient imagery in this opinion that channels this kind of popular constitutionalist norm of how people relate to the Constitution. And this was really what set things in motion. Because once you have courts striking this law down, that gives teeth to the challenge. Because now you know the challenge has legs. In our system of government, we have a couple tiers of courts. We have the trial court, called the federal district court. We have a court of appeals, followed by the U.S. Supreme Court. There were a number of Court of Appeals opinions that consider this. The Sixth Circuit Court of Appeals, I used to clerk there, but I was not involved in this case, upheld the law. The 11th Circuit, which is based in Atlanta, and heard the appeal from the Florida case, said, this law is unconstitutional. So now we have what's called a split of circuits. When you have one Court of Appeal that says one thing, another Court of Appeal says something else, you have a split. There's a different authorities. And the Supreme Court will generally take a case when you have different courts of appeals who disagree. Once the 11th Circuit said that this law is unconstitutional, you knew this was going to the Supreme Court because it was a split of authorities. And then there were a couple other Court of Appeals that also said the law was constitutional. So in a matter of, from March 2010, when the law was enacted, till about the summer of 2011, barely a year and a half had elapsed, the entire way that people kind of viewed constitutional law evolved. This really came out of almost, I was going to say left field, probably more like right field. It was quite unprecedented. And what made this challenge solidified was what happened in November of 2011. The Supreme Court accepted review of this case. But they didn't just accept review. They assigned it almost 6 hours of oral argument time. Usually the Supreme Court gives each case 1 hour of argument time. This case got 3 days with 6 hours spread over 3 days. That was largely unprecedented. There hadn't been that many hours for a case in years. This is the Supreme Court's way of saying, hey, this is an important issue, so we're going to take our time with it. A lot of people thought that the Supreme Court might just summarily reverse to the lower court and say, hey, this law is constitutional. We don't want to get involved. But the Supreme Court went through it full tilt. March 26, 2012, exactly almost 2 years to the date after the original law was enacted, the Supreme Court heard oral argument. The people aspect of this is just wonderful. There are only 50 seats to the public available at the Supreme Court on any given day. And those tickets are given on a first-come, first-served basis. So the way to do it is you actually have to wait outside the Supreme Court. The tickets are handed out at 6 a.m. It's almost like a concert. I slept outside the Supreme Court twice. It's not comfortable, because the sprinklers come on at 3 a.m. It gets very wet. And in Washington, in the middle of March, I actually was there a couple of years ago in March, it's really cold. It's very cold to be just camping out. And when the sprinklers come on, it wakes you up, it's really bad. So people lined up 72 hours in advance to get tickets to the Supreme Court to see this case. There are no cameras in the court, so the only way to witness it is to be there. And people were waiting there for 3 days outside. The first person in line I actually spoke to, she was a single mother from Atlanta. Her child had some sort of health condition, and had this law been struck down, her child would have lost coverage. A couple of other people were law students and various other people involved. You have to keep in mind that this is a law that affects people. It's not just about commerce and the Supreme Court. And these are the laws, the protests, the people outside. It's fascinating to kind of view all the human dynamics of this case, because there's just so much, to use the phrase of this term, humanities. There's a lot in this case. So argument was held over 3 days. I won't bore you with the details of the technical issues, but the main event came on day number 2, of whether the mandate was constitutional. Could Congress force people to purchase health insurance? And I'll tell you what, after reading the transcripts, I listened to the arguments as well. It wasn't looking very good for the government. It wasn't at all. Chief Justice Roberts, we all know eventually provided the ultimate vote to save the law, was extremely hostile and aggressive to the government's lawyer. Ultimately, Roberts had a very curious way of resolving the case, where he accepted this argument that the law is a tax, even though it's not called a tax. During argument, Roberts was beating the government lawyer over the head, saying, this is not a tax. How can you call it a tax? It's not labeled. But ultimately, he accepted that very argument. This kind of changed position actually gives credence to some of the rumors you might have read that Roberts switched his vote. I won't indulge in any rumors because I have no inside information, but there is circumstantial enough evidence to think that might be plausible. But at the time, it was seen that the swing vote was really not Roberts, it was Justice Kennedy. And Justice Kennedy was very, very, very direct. He asked the government, can you help me? He said, this law is unprecedented. Has Congress ever required people who engage in no activity to do something? And the government lawyer had no good answer. And that seemed to resolve the issue. I mentioned this earlier, but I'm actually writing a book about this case by the title of Unprecedented. I actually wrote an ending to this book before the case was decided. I was so confident in how the case was decided. I actually wrote how I thought the case would come out. That would save my drafting over the summer. Needless to say, to rewrite the book. But I actually wrote several op-eds with various outcomes of the case ready to be released on the day of the case. None of them worked. So that was kind of a waste of my time. But this case was seen as going down. I did a number of interviews with people on both left and right in the month of June before the case was decided. And the people on the left were like, oh my God, this is so bad. People on the right were like, yeah, we're going to win. And then I talked to the same people a couple weeks later, and it was the exact other way. People was like, oh yeah. And the liberals were like, I knew all along we'd win. Like, no, you didn't. And then the conservatives were, well, you know, I thought we had a, you know, it was a fifth. No, you thought you were going to win. So there was this huge, you know, shift in how people viewed this case, which is just fascinating. So anyway, what happened? So between March and June, the decision date came down June 20th, 2012. What happened? So Jan Crawford, who's a reporter for CBS, published this explosive report saying that Chief Justice Roberts switched his vote. Why? Roberts was afraid that the Supreme Court's legitimacy as an institution would be harmed if the court struck down this law. What does that mean? The courts are unelected. They're not really accountable to anyone but the democratic process. The court's ability to strike down laws and to be a respected institution is very closely related to how people perceive the court. If people stop respecting the court or view it just as a political institution, its legitimacy is harmed. People won't view it as a body that's operating in fairness and justice. It will simply be a body operating as politicians in robes. The theory goes that Roberts was very much afraid of what would happen if the court struck down this law. There would be a backlash. Perhaps the president would run against the court. Perhaps the president would criticize the court. He's done that before. Remember at the State of the Union a couple of years ago, President Obama, with the justice sitting right there, criticized him for the Citizens United decision. Justice Alito famously shook his head and said, not true. So we know this is a president who's not afraid to criticize and go after the court. In fact, a couple of days after the Supreme Court argument, President Obama was in the news saying that it would be unprecedented, he used that word, for the court to strike this law down. So the president had a direct, I don't want to call it a threat, but it was a blow to the court saying, don't do this. So the thinking was Roberts may have been afraid. So let's take a step back and think about this. When I opened up, I argue that the challengers of this law grounded it in notions of popular constitutionalism. The notion was that, hey, this law is very unpopular. People don't like it. You know, this will create a political climate where it will be okay for the court to strike down this law. This was the message. That because this law is something very unpopular, if the court chooses to strike it down, the climate will be okay for that to happen. But that door swings both ways. When you ask judges to kind of consider how people view the law in making their decision and what would happen, it can go either way. The same forces that may have led Roberts to want to strike down this law, saying that this is something unpopular, I have political cover to do this, may push him the other direction. It may push him to saying, if I do this, there will be a significant backlash against the court, and I'll end up worse off than I was before. So there might be some perverse incentives for using this kind of popular constitutionalist attack on a law of this magnitude. And what's fascinating is this kind of idea of popular constitutionalism has historically been associated with liberals. The Warren Court was very much a court in tune with what the people wanted and trying to advance society in a progressive nature. The modern legal conservative movement evolved as an opposite to that. It was grounded in restraint, textualism, originalism, strict constructionism. These are words you might have heard. It was this notion that courts should not be stepping outside the bounds of what the democracy enacts. But this case kind of reversed it. All of a sudden, many liberals and progressives saying, no, courts should be restrained. They should not be looking to these other factors of society, just stick to the precedents. And then conservatives, who for many years said, stick to the precedents, said, no, we should kind of broaden this and then kind of influence how the Supreme Court understands the Constitution by notions of popular culture. And it's very possible, and perhaps likely, that these kind of forces impacted the outcome of the case. Now, of course, we don't know for sure what happened. We don't know why the court did what it did. We do know, though, is that it almost worked. And I think there are a lot of lessons that can be learned from this going forward. For one, what does this mean for originalism? Originalism is a doctrine that says we should decide constitutional law cases based on what the Constitution meant at the time it was enacted. You know, how would commerce have been understood in 1787? Okay? That wasn't this challenge. The people who brought this challenge didn't make it about originalism. They made it about consistent with existing precedents. How do we fit this into the New Deal regime of constitutional law? Another issue is, what does this mean for liberals? Liberals were very much inclined to be very restrained and opposed to kind of to use the pejorative, an activist court. What happens in a couple of years when liberals are in the minority in the court and they want to advance some sort of new right? Will the same notions of restraint remain? Or does everything go out the window? Is this case so unique? Is it just sui generis? Is it a case by itself that all norms were out the window and both sides at all costs willing to win? I don't know. I really don't know. And I think there are a lot of lingering questions about this case and why I think it's so important we have a conference like this, a study from all the various angles. One issue for you, people do medical ethics focus on, is how, if at all, these notions of popular constitutionalism should be affected by access to healthcare. I think in large part you had a crash course in this case. You know, common law experts have become experts on medical law right away, and healthcare experts have become experts on common law right away. And I think there's probably a large divergence of knowledge and information among those various experts. And I think it's with that, I think I'll wrap up and open for questions. And particularly from this audience, I'm interested in learning how you felt about the case. Yes, sir.
Would you comment, please, on the government's approach to whether or not this was a tax, you know, when they were making their argument on bond there?
Well, the government was in a very strict position. The president made it clear that he wasn't going to raise taxes. He went on George Stephanopoulos' show in 2009-ish, and he said, I will not raise taxes. Stephanopoulos asked him, is the healthcare law a tax? Obama said no. Okay. When they were enacting this law, in earlier versions of the law, it was actually called a tax. As the law progressed through the drafting history, that changed. Although it was kept in the section of the Code impacting the Internal Revenue Service, which would suggest it's a tax, it wasn't called a tax, it was called a penalty. So you had this kind of almost bizarre situation where Congress wanted to enact a tax, but they didn't want to take the political hit for it. If the Congress had enacted a tax, then they would have been stuck with raising taxes. They did not want to do that. So the government was in this bizarre position that it wasn't called a tax, but it acted like a tax, so we should treat it as a tax. And that's how Roberts saved it. He called it a saving construction. He's like, well, it's not really a tax, but as a judge, I have the duty to find the most, easiest way to uphold this law, and I will read it as a tax. I mean, Roberts effectively had to rewrite the statute to get to his outcome. It wasn't a tax, but he read it as a tax. Yes?
Sorry, we're going to have to stop right there. That puts us at 30 minutes. I don't want to take time away from Brian. If anybody has questions for Josh, we're going to lunch right after this session, so feel free to chat them up then. Or if you have further questions, we can do that at the end of the mini symposium. But,
okay, thank you very much.
thanks to everyone who enabled me to be here, invited me. Same list of names that Josh stated. Enjoy conferences like this, so it's a mixture. And appreciate Josh's presentation right now. He mentioned a lot of things that I'm going to mention. So